Hello. You all have heard about right, about duty, and that is there in the Constitution. There can be different position on this. Somebody can say there should be right first, and after that, if there is a need, there will be duty. There can be another position that right cannot be executed, enjoyed without duty. There can be third view that right and duty should work together. They should exist simultaneously. There can also be other views that duty is the primary need. Right cannot overpower duty. That way, there can be different positions. But then, what position would be more rational, more justified, or somebody can say which one can be termed appropriate. Today, I am discussing right and duties in view of provisions made in the Constitution of India and its various manifestations with reference to one or two Supreme Court decisions too. As I say always, that when you are attempting a constitution related question in General Studies paper 2 in UPSC mains, two things you must keep in mind which may not be applicable everywhere but in most of the places. One, wherever there is a scope, refer to relevant articles or the provisions laid down in the Constitution. And the other one, wherever it is possible, please also refer to a decision of the Supreme Court of India on that particular subject or related to that particular provision of the Constitution. Also, you will have to give content. That content has to be structured well, focused well, and also it must contain the essentials that the question expects from you. See that one question is here which came in 2014. Question is, what do you understand by the concept of freedom of speech and expression? We all know that freedom of speech and expression is given as a fundamental right in the Constitution. Next question is, does it cover hate speech also? So, also will it cover hate speech? Third question, what do the films in India stand on a slightly different plane from other forms of expression? So, a general forms of expression on which one may expect freedom, and expressions in the movies in which there are also given freedom. Are these two sets of freedoms are equal or different? This is how the question has come. See that there are 34 words in the question, and if you look at it very clearly, you will see there are actually three questions in this. One, what do you understand by the fundamental rights which is called freedom of speech and expression? That is question number 1 or sub-question number 1. Sub-question number 2, whether freedom of speech and expression also covers hate speech. Question number 3, whether freedom of expression and speech in a movie and freedom of speech and expression in general life are identical or not. So one will have to give actually 3 answers which are interrelated, interconnected. One has to blend them properly within the given capacity of the usage of the words, whether it is 10 or 15 marks. Accordingly, you will have to decide that how much word you will be investing in it and how that blending will take place. Now, when you are discussing about right, first thing is that you will have to understand what is right. At least 1 or 2 lines in the beginning you will have to talk about what right is. So I am trying to give you an idea about what right is in brief. Right is not a static concept. It is an evolving concept. As the time passes, as the situation changes, as the context becomes different, explanation, meaning, scope, and the implication of right also get changed. The concept of right has been explained differently by different scholars. So first, as the time passes, the meaning and scope of right gets changed. Secondly, not every scholar, every thinker understands right in similar way. Therefore, because of this diversity or plurality in thought and concept over right, various kind of understanding about right have emerged over the period. There is natural right, legal right, historical right, political right, economic right, social right, and also there are idealist understanding, liberal understanding, Marxian understanding. So right has different meaning, right has different context, and right also interpreted from different perspectives. In some understanding, right will be a claim, while in other understanding, it can be entitlement, it can be privilege, or it is a justified expectation of a human being. A right is a claim of an individual when it is recognized by the community. A right becomes an entitlement claim when it is recognized, either in social context or by law or politically somewhere, and by the state. So that time it becomes a claim and entitlement. But right can be a privilege even if it is not recognized by the community or the state. For example, right to self-dignity or right to life. Now, whether state has recognized or community has accepted, but nobody can have even moral right to take life of another person. So therefore, it is very difficult to say that right has only one or singular or only one interpretation. But out of all these varieties, all these shades of thoughts, a few things emerge as continuing, as constant, as common. Which are they? That it is one way or other a claim or entitlement of an individual. It needs social recognition. That means others must accept when I am claiming or I am putting my entitlement before others. So others must accept it. That is called social recognition. Social acceptance is also essential. And third, in certain situation, it has to be politically recognized right. When we are existing as a political personality, we are existing in a political system, political environment, then also it requires recognition by the political entity, political system. Now let us go to the duties. So I believe that you have understood that what can be the conceptual position on right, briefly. Now, duty means that whether right will be considered as an absolute position. That means my claim is absolute, so therefore no further curbing or further limitation be imposed on my claim, on my right, whether it is absolute position or not. If it is not absolute position, then the duty comes. That means I must not claim that my claim, my entitlement is absolute in its meaning and in its significance. So, for example, that there is a person called John Locke. John Locke is known as the father of liberal thought, and liberal thought means right, liberty, freedom, equality, justice. This can be individual, this can be collective. John Locke, who is a 17th century thinker, even he said that if there is no law, there is no liberty. That means liberty cannot be absolute, liberty cannot be unrestrained. There has to be law. That means there has to be some mechanism to put limitation, restriction on liberty when there is a need. So without law there cannot be a liberty. Even the father of liberal thought, John Locke, accepted these propositions. 200 years after that, another English man or another thinker in Great Britain, he is known as John Stuart Mill. He again said that an individual can enjoy his freedom, his liberty to whatever extent possible, but until it harms others' freedom, others' liberty. That means the moment it enters into the domain of others' liberty, other freedom, then there has to be a restriction or limitation on an individual's or collective's right and liberty. Again, in this thought, what we find? That right cannot be unrestrained, cannot be absolute. So there has to be a balance that where I will end my claim or entitlement. That reasonable thought comes from the sense of duty. Every right indeed has a corresponding duty. Every right. Indeed, if you really look at that, no right can be absolute, no right can be unrestrained, and therefore every right is somewhere limited. And when we are putting that restriction either on ourselves or from external sources, this can be state, this can be society. So whenever that happens, that means a duty comes. So every right indeed has a corresponding duty. In careful examination, one would find that right and obligations are two sides of the same coin. So while there cannot be only duties but no right, At the same time, there cannot be a position where there is only right but no duty. So there has to be an interface. So this must be considered as the two sides of the same coin. However, if the citizens are only think about rights in a state or in a political system, and all obligations or duties are only with the state and rights are with the citizens, then an orderly, civilized life will be impossible, because everybody will start claiming for their rights. And they will expect that state must only serve their duties, and that will create an anarchic, chaotic society. Even Gandhiji, who is for self-rule, that means individual rights should get priority over all other rights, that Swaraj or self-rule, even he accepts that right comes to humans when they do their duties. So without duty, even the great thinkers who sacrificed their life, struggled through their life, even they did not accept that right cannot be an absolute concept. There has to be duty, and right and duty are two interlinked, interconnected subjects. Now let us have a look at Indian Constitution. The Constitution also recognizes the same idea that there has to be right as well as duties. Indian Constitution gives us two sets of rights. One is fundamental rights, another is non-fundamental rights. Fundamental rights are described, you all know, in Part 3 of the Constitution, and fundamental rights cannot be taken away permanently, but temporarily if there is such an emergency need, like we all were restricted from our freedom of mobility, freedom of work for some time, freedom of even education due to corona pandemic. So in such situation, or if there is a war, in that situation, there can be a restriction of right to mobility, right to travel. So only in an emergency situation where no other option is left, or restriction or curb can be imposed on the fundamental rights. Otherwise, these rights are fundamental. Fundamental means they are related to the very existence of human being. Non-fundamental rights are spread across the Constitution through various articles and provisions that are laid down in the Constitution, also the laws that have been enacted by this Indian state based on the provisions and articles laid down in the Constitution. They include natural right, civil right, legal right, moral right, political right, cultural right, economic right, and so on. All these rights are somewhere there in our country, in the Constitution and in various laws. So therefore, there are fundamental rights, and there are also other rights which are rights but not fundamental in nature. In 1976, the Indian government thought that duties must go along with, right, and this was a gap in the Constitution. Unless duties are also becoming part of the Constitution, these interface, these interrelationship between right and duties will not be established ideally or optimally. Therefore, the government of India at that time, they formed a committee under, it's known as Saran Singh Committee, and they recommended that 8 duties need to be inserted in the Constitution. As a result of these recommendations and other inputs that came through the 42nd Amendment Act of 1976, the government of India, instead of 8 duties which were recommended by Saran Singh Committee, it included 10 duties. So therefore, it becomes now 10 duties in the Constitution, and they added a new part 4 of the Constitution. Means already there is a what you call DPSP, Directive Principles of State Policies. Within that they add one more article called 51A, and in that 51A they enlisted those 10 fundamental duties. Which are those duties? Just have a brief look at them. We all know them. First is that to abide by the Constitution and respect the ideas and institutions, the national flag and national anthem. Secondly, to cherish and follow the noble ideas which inspired our national struggle and freedom. Third, to uphold and protect the sovereignty, unity and integrity of India. Fourth, to defend the country and render national service when called upon to do so. Fifth, to promote harmony and the spirit of common brotherhood amongst all the people. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities. To renounce practical practices derogatory to the dignity of women. Then F6, to value and preserve the rich heritage of our composite culture. Then 7, to protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have compassion for living creatures. Then 8, to develop the scientific temper, humanism and the spirit of inquiry. So I will bring your notice to certain words here. One is that in H, that is scientific temper, and then earlier that to value and preserve the rich heritage of our composite culture, and much earlier there is another word, that is to cherish and follow the noble ideas. So please remember these 3 words. One in 51A B, that is noble ideas. Then 51F, composite culture, and then 51AH, that is scientific temper. Then there are 9th, which says to safeguard public property and to adjure violence, and 10th, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. In 2002, through 86th Constitutional Amendment Act, the Government of India inserted one more duty. With insertion of this duty, we had 11 duties in the Constitution. What is new duty inserted in the Constitution to 86th Amendment Act in 2002? That is, who is a parent or guardian to provide opportunities for education to his child, or as the case may be, word between the age of 6 and 14 years. So already we had education as the fundamental right through Unnikrishnan judgment in 1991. Now it has made a duty also of the parents that they must ensure that 6 to 14 years of, children of 6 to 14 years of age must undergo education. So now we have 11 duties according to the Constitution of India. Remember that duties, by becoming the part of DPSP or it part of Part 4, it also now one component of the basic structure doctrine of the Constitution. So even duties cannot be changed, even duties will remain as it is. However, if you really look at it, since it is part of Part 4, that means DPSP, therefore DPSP is not enforceable by law. DPSP cannot be taken to Supreme Court for adjudication. So similarly, duties also are not enforceable and not adjudicable. However, many of the duties, can be brought within the domain of law or within the reach of law. For example, that the Prevention of Insults to National Honor Act 1971. We have earlier saw in duty 1 that nobody can dishonor national flag, national anthem and the national institutions, but this also can come within the Prevention of Insults to National Honor Act. So if somebody does not perform their duty, then this can be brought under this act too. Then there are also Indian Penal Code and many other criminal, crime related acts. Next is Unlawful Activities Prevention Act 1961. So if somebody goes against nation, if somebody goes against the other people, other citizens, then we have criminal procedures, we have criminal laws, and also we have Unlawful Activities Prevention Act, that is 1967, that also can be brought in. Then if somebody does not contribute to protect environment, animal life and biodiversity, then also we have Wildlife Protection Act. We also have a series of environmental acts. We have Water Act, we have Air Act, we have environmental law. So different kind of laws are there related to environment, and then again that those things can be brought within the purview of law. Then we also have the Representation of People Act 1950, and that also can be brought if there is any such situation where we find that lawmakers are not performing their duties and they are somewhere instigating in different way to create violence in society by creating rift among the communities. In connection to that, for further strengthen the position, the government of India formed a committee by the retired Supreme Court Chief Justice J.S. Verma, and they submitted their report in 1999, which again clarified some of the points on the areas of duties. So therefore duties are not fully enforceable. Perhaps this is not correct. So they can be enforced not by directly as directive principles, but by other laws which are already there in the countries. So that way, you see that how the Constitution is making a balancing between right and duty. Now, is duty something very unique for Indian Constitution? Definitely it is a unique feature of the Constitution, but not that no other countries have included duties in their Constitution. In fact, India has borrowed this concept from the former USSR, not Russia, when it is Union of Soviet Socialist Republic, when that was the country, and that time they had section of duties, and India borrowed it from there. So that itself shows that there are duties existing in various constitutions. So I am just giving some ideas about some other areas, like Article 43, 45 of Democratic Republic of Vietnam, they have duties. Netherlands Constitution has duties, Japan Constitution has duties, and then definitely as USSR I said earlier. Besides that, I am not going for various countries, there is no need. If there is a need, you can mention only one or two countries. But there is also a concept of fundamental duty in the Universal Declaration of Human Rights and the International Covenants on Civil and Political Rights 1966. So they are also including the concepts of duties along with rights. So even in human rights understanding, duties are not overlooked and duties are not undermined. Quickly, let us go for one or two case studies. Now, first case is very interesting case. You all know about the fact, but now you can relate it better. This is called Sham Narayan Chaudhse versus Union of India 2016. In this particular case, Supreme Court in its first judgment said that in a cinema hall before the movie starts, when that national anthem is sung, that time all the audience will have to stand up. And if they are not standing it up, then it will be a violation of duties. Now, because whenever there is a national anthem, then we are supposed to immediately stand and give respect to that. So therefore, in the movie hall, it is also necessary when it is in the beginning it starts. So that is what, and you all know that those people who could not stand up, lot of very very unwanted situations happened in that. Sometimes people are beaten up, people are thrown out of the movie hall. Lot of things were there. So these cases came for the review in the Supreme Court again. In the second review, the Supreme Court came to the conclusion that it is contradicting with the fundamental right of liberty under Article 19(1). Okay. So the first case says that play the national anthem before the screening of each movie and making it compulsory for all viewers to stand till during the national anthem. So it makes compulsory. Now problem comes. No, there can be somebody sick, there can be somebody does not want to doesn't want to disrespect national anthem, but doesn't want to get up also in a movie hall because he has come for for watching the movie. And making national anthem compulsory before the movie, some people may not like. There is a case also earlier when in a school in Kerala, 3 boys, did not, walked out when national anthem was going on, and that became a case. And in that case, the court came to the conclusion merely walking out when national anthem is going on does not amount to disrespect to the national anthem. That may be a very, very, very loose concept or loose interpretation of the duty. In this case, when the review petition came, then the Supreme Court, so it is a 2016 order where Supreme Court made it compulsory, and 2018 when it came, it says that it violates Article 19(1) as the unreasonable restrictions were put on citizens of the country, because citizen has a liberty, and this is making compulsory, creating undue restrictions. Therefore, they find that there is a duty is prevailing over fundamental right. That is what I was telling earlier, where the duty can prevail over. So there has to be an interface, not that one is dominating over others. So the Supreme Court came to the conclusion that this is contradicting with 1901, because there can be many reasons for people not to stand up when national anthem is going on. So therefore, Supreme Court took a different position. Another case that is also very early case, that is 1983 case, that is West Bengal Headmasters Association versus Union of India. In that case, what happened, that Headmasters Association went against the West Bengal Board of Secondary Education. In a state, normally there is a state secondary board and there is a central board of secondary education. Normally these two boards function simultaneously, and what happened that West Bengal Board of Secondary Education, they introduced a new history book where the volume of pages, number of pages devoted to national movement was reduced. Earlier it was more. So therefore Headmasters Association found that by reducing it, they are undermining the importance of national movement, and also there are other books which is covering elaborately that the schools are not introducing. On this issue, finally the Supreme Court interfered, and what they said, the contention is around the coverage of discussion of the national freedom struggle in the history book of the 8th standard, and there is said that both the books must be available, and students must have freedom, or schools must have freedom to read both the books. Okay, so this is how the Supreme Court gave a verdict on this case. And the third case, that is a very famous case, 1987 case called Rural Litigation Kendra versus State of UP, that is on 51G, environment and stone quarrying, that is in Dehradun area. That stone quarrying was going on, and that stone dust was spreading across in the nearby areas, and therefore fertility of the land and overall agricultural productivity was declining. So rural litigation went to the Supreme Court, and finally Supreme Court gave a restriction that you cannot have right to do your business at the cost of environment. So you must have a duty. 51J, excellence, means surpassing merit, okay, virtue, honest performance. So that kind of interpretation also came. Finally, the challenge of duties, implementation of duties are some of the vague terms. For example, as I told you, please remember that in 51AB we have said noble ideas. Now how to define that noble ideas? Again, as we have seen in the beginning, that right can have diverse plural concepts, plural ideas. Similarly, noble ideas can vary, understanding of noble idea can vary from person to person. So therefore defining noble idea is very difficult, and nowhere in the duty section the Constitution defines what does it mean by noble idea. Second, that composite culture, that is in 51A. Okay, composite culture means what is composite? Okay, again this is a not so clear term. Now again possibility of different versions remain. And third one is 51AH, that is called scientific temper. So which one is scientific, which one is not scientific? Again that becomes controversial. Because of this, sometimes it creates confusion, but definitely what we find from various provisions, various judgments and concepts, that right and duty must go together. There cannot be only right, no duty. There cannot be also a situation where only duties but no right. So thank you. I hope you have liked this presentation. We will meet again. All the best.